In this episode, Auditor Curno Audit is out working with a colleague when the police show up after a resident reports someone suspicious simply because he didn't look like he belonged. Despite doing nothing wrong, officers fixate on ID, ignore his rights, and unlawfully detain him. But Curno doesn't back down. He takes them to court, wins big, and even gets some of the officers fired.
Is that your badge number?
Well, I hope it is.
We'll just
take a photograph of it, please.
Yeah. Just wondering. I've got to prove it. Obviously, I don't know you from Adam. You could be someone just who's dressed up.
We're not going to do this for fancy dress, are we? Right. As my colleague explained, the reason why we stopped you is because you fit the description of somebody acting suspiciously. Right? Now, you've given a legitimate reason why you're here.
Yeah.
Right. But we need to see some ID and some proof that you are here legitimately.
No, I understand that.
Can we see that, please?
I understand that, but on another term, I have actually got human rights.
Is that your vehicle there?
Nope.
Okay. So, what form of identification have you got on you to say you're actually canvassing?
I've got ID on me, but I don't have to legally show it yet because I've not committed a crime.
Right.
Obviously, if you...
We've
had a phone call about some suspicious males, so we need to ascertain whether you say you are, but I think you're not going to give us your name.
I get this every week.
Verify. Yeah, but you've got to appreciate we get calls from members.
No, I understand that, but I'm doing a job, I'm paying me taxes, I'm earning money. Yeah. I mean, I don't understand. I have not committed a crime.
If you were calling us, surely you'd want us to follow it up, wouldn't you? That's why we've been sent here, to follow it up. We want to be rest assured when we leave here today that you're not up to anything suspicious.
Authorities cannot legally justify detaining or demanding identification from someone based only on a vague phone call. A report without clear evidence of a crime does not create lawful grounds for stopping an individual. In this situation, the officer's remark about needing to verify identity raises concerns, especially since the person never misrepresented who they were to begin with. The individual in question, an auditor, was simply exercising a legal right, choosing not to hand over identification when there was no reasonable suspicion of a specific offence. Under UK law, this right is protected. Citizens are not obliged to provide ID unless they are being lawfully detained under clearly defined circumstances, such as genuine suspicion of criminal activity. In this case, those conditions were never properly explained or established by the officers. Relying on a vague, third-party phone call as justification for demanding ID is a slippery slope. It allows room for profiling, unwarranted targeting, and the misuse of authority. Without evidence of an actual offence, fishing for identity is not just legally shaky, it undermines public trust and risks crossing into abuse of power.
I understand it in that way, but I'm not...
If your name gives you ID, we could ring SafeStar, say, and confirm...
Well, you can ring SafeStar and you can ask them if, obviously, if you've got canvases in this area and you'll validate who I am.
And what's your
name? Obviously, I'm not giving it out.
Well, when I ring up SafeStar UK and say, you've got canvases, and they say, yeah...
They know I'm in this office, they know I'm around here. Because we get issued to a certain area and they keep both names of the people.
So where's your ID card?
It is on me, but I don't have to show it. I've not committed a crime.
We're going round in circles here, aren't we, chap?
No, I don't mean human rights, mate. I've not committed a crime. Obviously, you're putting me under alarm and distress now. You both cover it going round me. Obviously, you're trying to say that I have to show my ID.
You're putting me under alarm and distress.
How am I?
It's our ID. We've shown you our ID. So
yeah, but at the end of the day, you're a public servant.
Rather than respecting the auditor's lawful position, that he has no duty to provide identification without reasonable suspicion of a crime, the officers continue pressing him. Instead of de-escalating, they shift the narrative and even go so far as to claim that he is the one causing harassment, alarm, and distress. The irony here is difficult to ignore, and it raises serious concerns about accountability. It's deeply troubling that trained officers, supported by the authority of uniform and law, could claim to feel distressed simply because a citizen calmly asserts their legal rights. That imbalance of power becomes even clearer when one officer tries to defend the demand by saying, "We've shown you our ID." But that argument misses the core issue entirely. The question is not whether officers can display identification, it's whether they are justified in insisting that a citizen provide theirs when no lawful grounds exist to be why portraying themselves as victims in this exchange, the officers attempt to flip the dynamic on its head. In reality, it is their repeated questioning, pressure, and refusal to accept a lawful answer that escalates the situation. Instead of safeguarding the law, their actions come across as an effort to override it. This kind of circular reasoning, demanding compliance without cause and then blaming the individual for resisting, undermines trust in policing. It is not just ineffective, it borders on an abuse of power.
Listen, chap, I may be a public servant, but I'm not your servant.
No, okay? I didn't say you were my servant, did I?
Okay.
I said, but if you're walking around with a police uniform which gives you powers...
Stop going on about YouTube, it's like this public servant, okay? I'm not a servant, I'm a police officer,
yeah.
okay?
Which means, but you serve the public.
I'm a police officer.
Right.
Okay. Police officer. I'm not a servant.
Yeah.
So let's get that quite clear before we start.
Well, there's no need to get angry, is there? Because now you're putting me under alarm and distress. Now I feel threatened.
When the officer responds with, "I might be a public servant, but I'm not your servant. I'm not a servant. I'm a police officer," it reveals more than frustration. It exposes a troubling display of ego and entitlement. Such words strike at the very core of public trust, because policing has always been built on the principle of service to the community. By drawing a line between being a public servant and serving the public, the officer signals a distorted view of authority and a fundamental misunderstanding of his duty. What makes this statement even more concerning is the context. It doesn't arrive in a calm, neutral setting. It follows repeated attempts to pressure the auditor, sustained intimidation, and a flat-out refusal to respect his lawful rights. Delivered in a dismissive and confrontational tone, the remark isn't just defensive, it carries an air of superiority. Instead of projecting accountability, the officer rejects it outright. This kind of rhetoric undermines the very foundation of democratic policing, where authority must always be balanced with responsibility to the people. For the auditor, who had done nothing unlawful, the remark only deepens the sense of harassment, alarm, and distress. It's not just words spoken in passing, it's an attitude that compounds the harm and highlights the imbalance of power in the exchange.
What, you feel threatened?
Yeah, hence why I'm recording it, just in case anybody's trying anything cheeky.
That's fine.
I've had it before where police has thrown me on the floor for asking him, "Have you got ID?"
So police officers thrown you on the floor?
Yeah.
And that's what I do.
I've asked for him.
Very strange.
Well, not all coppers are legitimate, are they? Not all coppers are nice. So at this moment in time, am I detained?
That's right.
What for? What am I being detained for? Have I committed a criminal offence? I've not committed a criminal offence. How can you detain me? Because then you're holding me hostage. You're now restricting my free way of movement, because now you're saying I'm being detained for a crime I've not committed. I will just literally. I'll send this to me my lawyer, mate. This is going straight to my lawyer.
First things first, we're recording it.
Yeah.
Has it just picked up the word that you just said to me?
Yeah.
Right. This is your first and last warning. You swear at me again, you'll be arrested. Do you understand me?
Yeah, but I'm asking why am I being detained?
Listen to me. Are you going to listen?
I'll listen, but I want you to listen to my point of view.
Detained at this moment in time.
Yeah.
So we can speak to the caller.
Yeah.
Because as I said, you fit the description of a person seen acting suspiciously.
Yeah.
Right? Now, until we speak to the caller and fathom out what the caller says to us, you're not going anywhere.
Right, so you're detaining me against my own will from a crime that I've not committed.
This incident highlights a clear misuse of police authority. Detaining a person without lawful grounds, based only on the idea that they fit a description or appear suspicious, falls far short of acceptable policing standards. Without evidence of a crime, such actions are not just careless, they amount to a direct violation of civil liberties and public trust. What makes this situation more concerning is the officer's own admission. He openly acknowledges that the detention is based solely on the word of a caller, with the auditor being held until officers can figure it out. But that is not how the law functions. Detention cannot be built on guesswork or unverified claims. It requires specific, reasonable, and objective grounds. Anything less turns lawful safeguards into empty promises. UK law, particularly under the Police and Criminal Evidence Act, PACE, is clear. An officer must establish reasonable suspicion tied to an actual crime before detaining someone. A vague phone call does not meet that threshold. By treating the auditor as if he were guilty until proven innocent, the officer reverses one of the most fundamental principles of justice. Instead of protecting rights, the approach here undermines them, leaving the impression of policing by hunch rather than by law.
Are you going to admit that now on camera, that you're detaining me when I've not committed an offence?
Till we speak to the caller.
Yeah.
See exactly what the caller says you have or haven't done.
Right, but technically you can't detain someone if they've not committed a crime, because then that's holding them against their own will.
Well, once we speak to the caller,
yeah, but now
the crime has been committed, then I will tell you what's going to happen next.
So you're actually admitting you've illegally detained me for a crime I've not committed?
We haven't illegally detained you.
Well, if you've not detained me, then I'm free to go.
Tell you what, walk up there then, we'll follow you then if you need to speak to you again.
But then it's harassing.
Off you go.
But then it's harassing.
It's not harassing.
No, what I'm saying is, if you'd like to leave,
right.
if you'd like to leave now and walk whichever way you like, carry on. And if I need to speak to you at a different time, I'll come after you and have a word with you.
The officer's response in this exchange is deeply troubling and reveals a startling disregard for lawful procedure. Faced with the auditor's valid concern about being unlawfully detained, the officer dismissively offers, "How about you walk away and we'll follow you?" as if shadowing a citizen somehow resolves the problem. In reality, it does the opposite, it intensifies it. Surveillance without any legal foundation amounts to harassment. Once the auditor has made it clear that he wishes to be left alone and is within his rights to do so, following him is not an act of caution, it is an act of intimidation. The officer is essentially proposing an informal stop, not based on evidence, but on the hope of justifying suspicion later. That kind of tactic undermines the very safeguards designed to protect individuals from arbitrary policing. This is a textbook example of intimidation disguised as procedure. If an officer lacks the legal power to detain, then continuing to shadow someone under the vague possibility of needing to speak again is not only unreasonable, it is oppressive. Such conduct erodes trust, blurs the line between policing and harassment, and shifts power unfairly against the very people officers are meant to serve.
I'll just put a complaint in. I'll just put a complaint into IPCC.
That's fine. That's fine.
Because obviously you're illegally detaining me for a crime I've not committed. So obviously, like I'm going to ask again, am I being detained for a crime? Because obviously now no one's answering. If I'm not being detained for a crime...
I'm just in the process of speaking to your manager.
Right.
If you'd like to walk away, you are free to walk away. And if I detain us a crime, I will come after you, won't I? So it's up to you, sir.
I'm not going to turn me back. I'm not going to turn me back on officers so you can body slam me.
Do what you'd like. I don't think I'm capable of body slamming.
Hey, there's police out there that body slam people for the fun of it.
When he's asked for an officer's ID.
So you've illegally detained me, you call me a liar. Yeah, but now you've also illegally detained me. So wait until IPC.
No, we're going around in circles. Twice I've said, if you'd like to walk away, walk away.
Well, just for the camera, have I been committed as a crime? Right, so I've not committed a crime, so... Well, you've given me permission to walk away. I'm not, mate. I'm not, mate. Now you're making lies about me. You've also illegally detained me, like I said before, when he says you're now detained. For what crime? He couldn't give me a crime. So he's legally detained me on the spot. He's also kept me hostage. So I do know my rights, and this will be going to IPCC. I will be sent it to Milan. I'll wait until it's all over line. I don't need the log number. I've got your badge numbers. Because I don't trust it. I don't trust the fact I can walk away with you.
I've been showing us your ID in the first instance. I don't think it would have taken this long. So when you're talking about being...
Yeah, but I don't have to show my ID if I've not committed a crime or I'm on suspicion of crime. I've not committed a crime. I'm working.
The officer's remark that the situation would never have escalated if the auditor had simply identified himself exposes a deeply flawed way of thinking. Instead of recognizing their own overreach, the officers attempt to shift responsibility onto the individual who was only exercising his rights. This approach blames the citizen for not submitting, rather than holding the police accountable for acting without lawful grounds. The facts are straightforward. The auditor had not committed any offence, had openly explained that he was working, and clearly stated his legal position. At that point, the lawful course would have been to respect his choice and move on. Instead, the officer framed the auditor's refusal to comply as the root of the problem, as if saying no to an unlawful demand was itself an act of defiance. What this really reflects is not procedure, but ego. The inability to accept a lawful refusal led the officers to double down instead of reassessing the situation in line with the law. By suggesting that the auditor caused the escalation, the officer reveals a mindset that treats non-compliance with questionable demands as grounds for detention or further confrontation. That line of thinking is dangerous. It replaces policing by law with policing by force of will, and it risks normalizing escalation any time authority is challenged, even when that challenge is entirely lawful.
If working's committing a crime, I'll just go and join benefits.
You could have last time you were working 10 minutes ago, and you could have gone on your way then, couldn't you? So
we'll have to go so we don't have body slamming. So we don't body slamming.
Before you get that urge.
Yeah. Okay. So, it's what I said. Free to go, Sam?
Yeah, I'm just waiting for you to leave.
I took them to a criminal court and a civil court. At the criminal court, I was awarded £35,000 because of the incorrect ways and the way they did the jobs, which was performed illegally. Officer Stephen Haynes PC Jarvis and PC Warwick. One of them was suspended for 2 months with further investigation. One of them was fired, and the other one was given a slap on the wrist and was allowed to still do the job, but under investigation by their own force.
That £35,000 compensation payout speaks volumes. It doesn't just reflect the harm done to Curnow, it exposes the scale of misconduct by the officers involved. This wasn't some minor incident that could be brushed aside. It was a serious legal reckoning, the kind that only comes when rights have been severely violated. Courts don't hand down that level of compensation lightly, and in this case, the outcome confirmed just how badly the system had failed. The disciplinary fallout told its own story. One officer was dismissed outright, another suspended for 2 months pending investigation, and a third left facing an internal review despite receiving only a minor penalty. That lineup makes it clear, this wasn't a misunderstanding or a moment of poor judgment. It was a systemic breakdown, driven by officers who either lacked knowledge of the law or chose to ignore it. From the start, the handling of the situation was a blueprint for how not to police. Acting on nothing more than a vague phone call, the officers approached with suspicion instead of professionalism. Rather than assess the facts, they rushed straight into demanding identification without lawful grounds. When Curnow calmly stood his ground, exercising his rights, they didn't de-escalate. They escalated, with force and detention, not because the law required it, but because they couldn't tolerate being told no. The male officer's infamous line about not being a servant summed up the attitude at play: ego over service, power over accountability. And the female officer's suggestion that the encounter would have gone more smoothly if Curnow had simply given in revealed an equally troubling truth: an alarming disregard for civil liberties. That is not policing. That is coercion. Every step the officers took demonstrated a misuse of authority. The unlawful detention, the attempts to justify their actions by clinging to the caller's vague account, and the constant deflection all highlighted a lack of proper procedure. It wasn't about enforcing the law, it was about control. And when their justifications collapsed under scrutiny, they doubled down with dismissive remarks, even suggesting that Curnow was wasting time. In the end, it was their own conduct that wasted time, shredded credibility, and triggered heavy legal consequences. This entire case is a warning shot to any officer who believes they can bluff their way through the law. It also serves as a powerful reminder to the public: never be afraid to assert your rights. For the officers involved, the cost was reputational, legal, and professional. For the public, the lesson is invaluable. Accountability works, and knowing your rights is your strongest shield against abuse of power. That wraps up today's coverage. If you found this breakdown insightful, don't forget to like, comment, and subscribe. It helps me continue bringing you independent analysis of cases like this.